Henry is excused for the day. We're going to go with the jury instructions. So this is the charge conference. So I know earlier I was provided a set of the proposed jury instructions, and you have those too. Is that correct? Who's handling this for the defense?
Yeah, we do have them. I think there may have been some edits to that you received.
Going to replace everything from count 1 premeditated murder all the way to page 1 of manslaughter count 1.
So I'll insert those as we go. All right.
Yeah.
And Howard, you have everything? Yes.
Yes, I'm about to get the supplements.
So, first one I have is 2.7 closing argument. Your objection, state?
No, Your Honor.
Defense?
No, sir.
The next one I have is the 3.1 introduction of final instructions. Any objection, state?
No, Your Honor.
Defense?
No, Your Honor.
And I have 3.2 statement of the charge. Any objection, state?
No, Your Honor.
Defense? Then it starts out with 7.1 introduction to homicide. Any objection?
Not from this name.
No, Your Honor.
The next one I have is 7.2 premeditated murder first degree. Now this is the one that's been substituted, is that correct?
Correct.
Actually, Your Honor, back at 7.1, the second page of 7.1, at the very last paragraph, first line, where it says, I now instruct you on the circumstances that must be proved before Jamell Demons may be. We would like it to read, I now instruct you on the circumstances that must be proven beyond a reasonable doubt, as opposed to proved.
Thank you. And
Judge, I'd like to make another argument regarding this section. We would suggest that the actual superseding indictment in this case reads in pertinent part. The defendant did unlawfully kill the victim, and the defendant committed the offense for the purpose of benefiting or promoting the interest of the gang.
That's the
Oh, we're
next
not there yet.
We're going
Oh,
to
I'm sorry.
Yeah.
We're going to that.
As to that second page of 7.1, Your Honor, in place of the standard introduction homicide instruction, it reads as...
And you don't disagree with that, you just want to word it a little different, is that correct, Mr. Howard?
Yeah, it says proven beyond a reasonable doubt is the standard of law, so we would ask that that be substituted for the word proved. I think that every step of the way the jury needs to be reminded first.
Thank you. Objection, no, it's over. All right, we use the standard. Then comes up 7.2, premeditated murder, and this is the one that you've amended, correct?
Correct, Your Honor.
And it now has count 1, 7.2 premeditated murder, first degree. Am I correct?
Yes.
And have you seen that, Mr. Howard?
Yes, Your Honor.
Is there any objection to this?
Ms. O'Shea is going to make the argument.
Judge, as I was saying, the superseding indictment is worded, I think, in a rather interesting way because it suggests that the proof needs to be the proof of premeditated murder. And the way that the indictment is worded, it says, and the state must prove that it was also for the purpose of benefiting or promoting the interest of the gang. We would suggest, Your Honor, what the superseding indictment does in effect is it adds 2 more elements to premeditated murder. And in order to prove premeditated murder, then the state would have to prove that the victim is dead, that the death was caused by a criminal act of Jamell Demons, that there was premeditated killing, and that as well, there'd be a 4th element that says that he was a member of a criminal gang, and a 5th element saying that it was done in furtherance of said criminal gang. So we would suggest that that is all part of the state's proof regarding a conviction for premeditated murder. The way that it is charged in the indictment, which obviously has to follow. This argument would continue and be charged this way in both these sections as well as in second-degree murder, manslaughter, and felony murder. So this objection would go to all the appropriate sections of the charge.
Thank you. And what's the state's position on all of this?
The state would say this is an aggravation, not an element. In support thereof, the state would cite to Richardson v. State.
I don't think she's disagreeing with that. I think she's suggesting it's not, that it's a, typically it's not an aggravation. She's saying, the way I understand your argument, counsel, is you're saying is how it's worded in this case is incorrect, and therefore it's more than an aggravation. It's something they're alleging should be basically creating a new element or something to prove.
That's correct, Your Honor. And if I can just add, it's really, although it's generally a gang enhancement, I mean, what can we really enhance here? We're talking about a first-degree murder charge. There is certainly an aggravator in the death penalty section of this for gang enhancement, but as far as first-degree murder, I mean, what can you possibly enhance that to?
Mr. Your Honor, in support thereof, the state would cite to Richardson v. State, 338 Southern 3rd, 1106. That's a 2022 case. It is a first-degree murder by a criminal gang member. So I'll give her a copy of the affirmed opinion in that case, as well as the indictment, the jury instructions as to count 1, the first-degree murder, as well as the verdict form as to how it was written in that case. Those have already been provided to defense counsel.
And if I can just add, Judge, for the Richardson case, this was never brought up on the appeal. I don't know why it was never a question that it was never brought up on the appeal. Also, it really wasn't addressed in the appellate opinion.
I apologize, but I know I do with my copy. You got an extra one there?
Yes, sir. And I also sent 3.14, which is the discussion of score sheet findings for aggravators and things of that nature, which furthers the state's position that you cannot add an element to that. And there's actually a standard instruction for criminal gang as a criminal punishment code score sheet enhancement as part of 3.14. I'm handing a copy to the court and defense counsel.
Unfortunately, Judge, the indictment did exactly that. It added this as an element. And the indictment is what we have to try.
So Your Honor, for that to be a correct statement, and for defense counsel would then have to also argue that the actual possession or discharge of a firearm was an additional element of the homicide, of which it is not.
Thank you. All right. And I understand what the argument is. They're suggesting that the way it's worded, it's not an enhancement, it's actually making it part of the offense, the way the indictment is worded. And, all right, so I understand what the argument is. Is there anything further? No, that's, your objection, no, it's overruled. I think we're going to follow the standard instruction and treat this as an enhancement, not as an actual element of the offense of first-degree murder. So, in any event, objection, no, it's overruled. So what else? What other arguments are there regarding premeditated murder, first-degree count?
Regarding 7.2, Your Honor, on the third page where it goes to criminal gang member, at the end where it has the enumerated or the alphabetized.
A through I or whatever?
Yes. The problem with this case, Your Honor, is twofold. One, we had a witness who testified as an expert in contravention of some of these statutory requirements. He indicated, now here it says that a criminal gang member is a person who meets two or more of the following criteria. But as the testimony was adduced from their gang expert, somebody who wears red and throws up gang signs is not necessarily a gang member. So we have a testimony from their expert, the state's own expert, that contradicts the statute in terms of what is required for the jury to make a finding of criminal gang membership. Beyond that, so we would object to Section B, which indicates one of the criteria being adopts the style of dress of a criminal gang. In other words, wears red. I think that is dangerously prejudicial to give to a jury. C, adopts the use of hand sign identified as used by a criminal gang, which we already saw. We have everybody from 10-year-olds doing it on YouTube all the time, so that is, notwithstanding what the statute says, the evidence that's adduced in this case would make this jury instruction misleading. I think subsection E associates with one or more known criminal gang members. I think is constitutionally offensive to the extent that it kind of ignores the fact that people grow up in neighborhoods and have friends and what have you who take different paths in life. And the notion that unless you immediately dissociate with them, you are a member of whatever gang they joined, I think has socioeconomic and racially, constitutionally offensive implications. And finally, with respect to Section H, which says, has been observed in the company of one or more known criminal gang members for 4 or more times. The evidence that the state put on, they denied that either of the 2 decedents were gang members, and they put on pictures of Mr. Demons at concerts, taking pictures with fans who may or may not have been in the gang, may or not have been wearing red. But I'm in a fraternity myself. If I see Kevin Costner and I take a picture with him, it doesn't mean that he is therefore in my fraternity. So particularly where we have a situation where we have a celebrity who is prone to take pictures with fans of all walks of life, to invite this jury to conclude that the pictures that the state put up of him taking pictures at concerts with people is sufficient for them to find gang membership, I think, is misleading and improper. So we would object to subsections B, C, E, and H on those grounds.
Hey, what's in the state?
Judge, the standard jury instructions essentially list a host of different options that the jury can find. The jury can agree or disagree with the defendant as to B, C, D, E, or F. These are all conform to the testimony of Detective Danny Homo. So that's why the state left all those in subsection. Specifically, you recall the testimony where he spoke about the color that the gang members wear, the different type of hand signs. He talked about different hand signs displayed to the jury. He talked about the defendant's associations with known criminal gang members, including what was evident in the text messages, the 9807 phone number, and also, again, with the observations of other individual gang members within the numerous photographs that were displayed throughout Detective Danny Homo's testimony.
Is there a standard instruction on? There's not.
No, Your Honor. With the assistance of the Richardson case and the Florida statute 874.03, we created these instructions.
And does this mirror the Florida statute 874?
Yes, Judge, it mirrors 874 subsection 3, which defines criminal gang membership, and it goes A through K, and we did remove, I think we removed K, which states, for instance, has authored any communication indicating responsibility for the commission of any crime by the criminal gang. We also removed is identified as a criminal gang member by a parent or guardian because that did not come forward with the testimony.
Thank you. Anything else?
Nothing from the state.
Stand on that argument, Judge.
Thank you. Objection, no, it's overruled. As long as this mirrors what the statute is, it means that there's evidence from the detective regarding each one of these. Objection, no, it's overruled. That's as far as count 1, 7.2. Any additional issues with count 1?
No, sir.
Not from the state.
So it's the same issue with count 2, correct?
Yes.
And you're preserving that, but it would be the same ruling. I'd allow it.
Understood.
All right. The next jury instruction you're looking to have the jury instructed on is 7.3 felony murder. Is that right?
Yes, sir.
Yes, Your Honor. The state gave you defense counsel the Pierce case this morning, as well as a memorandum of law that discusses the other times Pierce decided. Defense counsel specifically asked if I had any cases in which the felony murder was, or the murder of another human being was the underlying felony. So I'm providing Lynch v. State 2 Southern 3rd 47. It's a 2008 case with the Supreme Court of Florida, and it starts on page 14 of the printed copy and goes on to page 15, which discussed that specific scenario in which another murder was the basis of the underlying felony for that. And so, with regards to the Pierce case, it's well settled in Florida law. The Pierce case is, I believe, 1995 or 1997. That has cited that has been the state of the law in Florida, where as long as the defendant is charged with murder in the first degree and that is a limited number of felonies under which the state can proceed, that is sufficient notice. As well, it goes into the fact that Florida is a very liberal state when it comes to discovery. Defense counsel has been aware, as all parties are aware, that there are 2 individuals that were killed during the course of this homicide.
Yes, Your Honor, we're not arguing a lack of notice. What we're arguing is that the state's interpretation of during and in the course of another felony deviates from common understanding of those terms and the definition of those terms in the English language. If, for example, I attempt to shoot one person and I end up shooting another, then I have killed that second person during and in the course of my attempt to shoot the first. That would be a felony murder. If I shot one person and the bullet went through that person and hit the other person and killed them, then the second person, I would be guilty of felony murder for that second person because it was committed during and in the course of my killing of the first person. If I tried to push somebody off a building and I ended up pushing them both off, then it would be a felony murder, or ended up pushing 2 people off. It'd be a felony murder because I have committed one murder in the course of my commission of the other. But what the state is suggesting is that if you kill more than one person at the same time, that in sequential order, that the killing of one of the first or the killing of the second is in the course of the killing of the first, which is nonsensical. And the Lynch case, the language that the state points to on pages 14 and 15, I think makes the case. Even though the state is relying on citation to a particular section, the language on their first-degree murder on page 14 reads as follows. We find no deficiency with regard to the factual proffer as it addresses Lynch's 2 first-degree murder convictions. The proffer, upon which the trial court relied in accepting Lynch's plea, provided sufficient factual support for each first-degree murder conviction. It then goes on to describe the facts. It says, according to the proffer, Lynch arrived at the victim's apartment, held the daughter victim, Leah Cadet, hostage. That's the felony. And then subsequently shot and killed both victims after the mother victim, Rosanna Morgan, arrived at the apartment. There were no deficiencies. Lynch's killing of Morgan was an intentional, premeditated first-degree murder, and his killing of Cadet was both first-degree felony murder and first-degree murder. If killing one person at the same time or in the same sequence of events as killing another person constitutes felony murder, then what the court would have said would be that the killing of both people was both premeditated and felony murder. But it only singled out one. And that's because the person was being held hostage. And that was the underlying felony. If, as the state says, the mere fact of killing someone else in sequence constitutes the underlying predicate felony for a felony murder charge as to the second person, then what the court would have said here in Lynch is that in each instance, both were both felony murder and premeditated murder. But it said it only as to one person. And that's because Cadet, who is the person who was being held hostage, is a person that was both killed pursuant to a first-degree felony murder and first-degree murder under the doctrine of transferred intent is what it says. But Cadet is the person who was being held hostage, and that was the underlying felony. It's not the sequence of murders. Once a murder is done, it's complete. And if somebody turns the weapon to another person and shoots that person, they're not shooting that second person in the course of shooting the first person. That crime has been completed, and both common understanding of English language and common sense dictates that one is not being done in the course of commission of the other. They're separate and independent acts, and we would object to any felony murder instruction under that theory, under the theory that the state advances.
Bring it back. Counsel, I haven't sufficiently read and digested the Lynch decision. I wasn't aware that this was going to be an issue. So as to this portion, my thought is I'm going to defer ruling right now. But before we go further, what my thought process is, I think the defense is right. So I don't know. I need to research it further and find out. But it seems to me that the way I read the case and what Mr. Howard indicated is correct.
So, Your Honor, you have the Pierce case as well, the state provided this morning.
Well, the Pierce case I'm familiar with. I've seen that case before and read it before. That's a little different.
And that one says that the state does not have to prosecute or does not have to allege in an indictment both premeditated murder and felony murder.
Correct.
And so that's the state's position, is that the state can then still go forward on both theories based on the Pierce case as well as Lynch. And the interesting part in the Lynch case, or in the state would point out, is in Lynch, the court specifically cites to 782.04 sub 1 sub A sub 2 sub O, murder of another human being, not kidnapping, as the predicate felony on that. And here the state would submit that in this case, there is clear evidence that, especially with regards to the count 2, the victim Christopher Thomas, that it would be during the course of the murder of Anthony Williams, which was a premeditated homicide, that specifically with regards to Christopher Thomas, that was the individual in the backseat, that there was the defensive wound, if I recall, that would be during the course of the murder of Anthony Williams, Christopher Thomas was then killed.
Thank you. So, anyway, I'm going to defer ruling on it. I want to read the cases. I haven't. I want to read the Lynch case over again.
We understand that, and I appreciate that. Just to the extent that the court does process the information and comes back, we would have some retort to what the state said at that time. I think now would be premature, or if you wish to hear it now. That's
I wish to hear this.
Okay.
I'm just going to end up ruling on it and sending an email out.
Makes sense. Well, first of all, I'm not sure that the medical examiner, matter of fact, I am sure that the medical examiner did not establish which of the two decedents was shot first. That's one. And this issue of a defensive wound that came out of the mouth of Christopher Williams, the sergeant, contradicts the testimony of their medical examiner that said the head shot was the first shot. And so the state is trying to ride both horses at the same time. If the state has receded to the position that at least the second person who was shot, there is a felony murder charge for that person, we would take the position that the state has not presented any evidence that would rise to the level of reliability, let alone proof beyond a reasonable doubt, as to which person was shot first. The medical examiner couldn't say, and Christopher Williams had his wild speculative theories that contradict the testimony of the medical examiner as to Christopher Thomas's first shot, which is in the side of the face versus the finger. And so I don't think the state has laid the factual predicate to establish which of the two was shot first, in which case, if it's a position that they have now backed down to is, or as an alternative, I understand, is that, well, at least as to the second person, we would have a felony murder charge. Our contention is that you'd have to establish which one was, and they have not done so. Which of the two people was shot first. That's it, Your Honor. That's all I wanted to supplement with.
Thank you.
Thank you.
Defer ruling. Take it under advisement. You'll hear from me.
The next with which we take issue, or maybe we should just go in order, because I now have them all scrambled.
Yes, I just keep an order, please.
Yes. What would the next be?
But we had just completed, in both cases, count 1 and count 2, 7.2 premeditated murder, first degree.
Yeah, I can't figure out with the supplement, but would the next in order be 3.9?
I think the next in order is the felony murder, which
Is it? Right.
I don't know, whether that's going to be given or not. I understand you object to it.
Okay.
And assuming that I deny your motion and I grant the felony murder, is there some language in 7.3 that you object to?
No. If it's, we don't, we object to it in total.
All right, so assuming that it's I disagree with you, there's no other objection as to the form of the order?
No,
The
sir.
form of the instruction?
No.
All right.
Except for the games that were just previously argued as well.
Which we, yeah, which we, yeah, the gang stuff, which we indicated goes through all of these instructions.
All right, and and that's for felony murder regarding both Mr. Thomas, the deceased Mr. Thomas, and Mr. Williams, correct?
Yes.
All right. So then, the next issue that I have is 3.4, when there are lesser included crimes or attempts. Are there?
Well, Judge, I know category 1 is second-degree murder and manslaughter. The state's only requesting manslaughter, but I believe that's requesting second-degree.
No, we're not.
So you would agree to take out second-degree murder and leave the manslaughter.
All right, so as far as the manslaughter instruction, have you seen the form instruction, Mr. Howard?
I have seen what the state has proposed.
Is there any objection to that?
No,
No objection.
except for the gang stuff, as you, to the extent that it exists.
All right, and I've already overruled the gang portion. That, my understanding, the law, that gang issue also carries over to the other charges. The statute itself would apply.
Yes.
So your objection is noted as to the manslaughter charge regarding the gang, but that objection is overruled, and the state's going to take out second-degree murder.
Correct. And I'll make a new 3.4.
3.4.
All right, so after the 7.7 manslaughter instruction, there's going to be 2 of those, one for Mr. Williams, one for Mr. Thomas, right?
Correct.
And the only objection is to the gang language, and I'm overruling that objection, so I'll allow that. So the next instruction I have is 3.5A, principles. Is that what you have, counsel?
Yes.
Any objection?
Not from the state.
It's a standard, we think that the instruction deviates from the evidence as proposed by the state and its theory. And for that reason, we believe it will be confusing, but that's our only objection.
Judge, may I approach with a new 3.4?
Yes, ma'am.
Okay, just print them all for me, one shot. Or email.
So, state which be heard regarding 3.5A, principles.
No, Judge, this is standard. We charged in the indictment the principal statute, 777.011. We're alleging that the defendant and Cortlen Henry are principals to the offenses, and the evidence supports and such.
So my only question was, I thought I saw the principal instruction actually in the body of prior instructions. Was that not the case? Did I miss something, or?
No, I think 3.5 is the, oh, yes, it's in the felony
The felony
murder.
murder.
Yes, it's in the felony murder because you have to allege the underlying felony, which is the argument. So essentially, you have to allege what the underlying felony was. So the underlying felony would be the premeditated murder.
Okay.
And with respect to that, Your Honor, further to our argument, they would have to name who that person is, and they can't just pick one or the other. So they have no evidence as to who was shot first. And so therefore, it actually underlies and addresses our point that the felony murder, even though they aren't put it in the indictment, the fact that they have to list it in their jury instructions and the underlying murder must be identified and they don't know which. It's a toss-up. Is kind of further support for the fact that it should not be included.
Thank you. So the next one I have is 3.7, plea of not guilty, reasonable doubt, and burden of proof. Is that correct?
Yes, Your Honor.
Is there any objection? That's the standard, correct?
It's a standard, Judge.
No objection.
3.9, weighing the evidence. You took out one of the paragraphs I saw.
Yes, Judge, I took out the reputation, that there was no reputation evidence, so we removed that.
Otherwise, it's the standard.
Only on this particular one, we removed accessory or informants on that, so.
So in the 1 to 10, I only removed the reputation. But on the second page of 3.9, accomplices.
I'm not hearing you, counsel. I'm sorry.
Oh, I was responding to counsel, but in 3.9, in the standard instruction, the only thing that was removed in the 1 to 10 was the reputation that I previously indicated. But on the second page, where it starts with expert witnesses, it's missing the paragraph regarding accomplices and informants, referring to Cortlen Henry.
What does that language say?
I'm going to print it.
You had previously taken it out and you want to put it back in?
I misread the comment. And it's the standard approach. My apologies.
No. You do it.
The big thick paragraph.
Yes. Regarding Cortlen Henry's statement that was read to the jury. And I just removed the second and third bracket, which says that he's been promised immunity or hopes to gain more favorable treatment, as those don't apply.
I don't know about that.
Okay.
With the inclusion of the language we believe to be appropriate. I think that it is entirely within the province of this jury to assume that Mr. Glass, Trayvon Fetty Glass, who testified behind the monitor and behind his dreadlocks, was here and was acting with a hope or expectation that he'll be favorably treated. So, whereas we agree that it was not established that this state attorney offered him anything, his motivation for showing up because he thought he was going to go to jail if he didn't show up, and the manner in which he testified, his entire comportment suggests that he had some ulterior motive, and I think the jury should be instructed that if that is what they found, that it is relevant to their consideration. And they may well have gleaned that just from the entire totality of the manner in which he appeared here and the manner in which he testified.
Davis, be heard?
Judge, I have no objection if they want it in, so you want me to put and or between those three brackets? Or. So for instance, the claim to have helped the defendant commit a crime and or has been promised immunity from prosecution and or hopes to gain more favorable treatment.
Yes, that's fine.
Mr. Howard, any other objections to that instruction?
And to that instruction, no, sir.
Mr. Turner, I'm going to try to work here on this one. You are saying the first one, claim to help the defendant commit a crime could be applicable? No.
No, we claim that is not applicable.
So it should only be hopes to gain more favorable treatment in his or her own case. Would be the
Yes.
only one that applies. Okay. So we don't need to and or with these two. And it's in the third one. Sure.
For example, some claims.
Who has
Who has?
been promised immunity from prosecution or hopes to gain more favorable treatment.
In terms of that there's no evidence of immunity from prosecution. So if hopes to gain more favorable treatment, we would agree that that should stay in, but there is no promise of immunity.
We can look at it.
Okay. A witness who hopes to gain more favorable treatment. That's the only one that's it. Got it?
Mr. Howard, is that right?
Let me consult you. 1 second, please. Yes, sir, that's it. We're good.
Okay. Proceed with the legal.
Thank you.
The next one I have in my packet is 3.9, subsection A, defendant not testifying. That's the standard, correct?
Yes, Judge.
Is there any objection?
No objection.
Then I have 3.9, subsection B, defendant's statement. It's a standard, correct?
Yes, Your Honor.
Any objection?
We object, Your Honor, because we believe that this, I don't know, do I have to make an argument?
No objection, and I only put it in as the defendant's request.
3.9. The parties agree that it should not be.
Both sides agreed to delete it.
Yes, Your Honor.
3.9B is deleted. Then I have 3.10, rules for deliberation. Any objection? That's a standard again, correct?
Yes, Your Honor.
Any objection to it?
No, Your Honor, we would just request that in paragraph number 5, that it says your duty is to determine if the defendant has been proven guilty or not. Instead of in accordance with law, that law is beyond a reasonable doubt. So we would ask that it read, your duty is to determine if the defendant has been proven guilty or not beyond a reasonable doubt.
They wish to be heard.
Judge, this is a standard instruction. We object to any special amendments to it.
The objection is sustained. It's the standard. 3.11, cautionary instruction. That's the form of the standard, correct?
Correct, Your
Is
Honor.
there any objection?
No, sir.
3.12, verdict. Any objection? It's the standard again, correct?
Yes, Your Honor.
Any objection to it?
It would only be, I believe, as to the third paragraph, and that is only as it relates to, because it
Depending on your Honor's ruling.
depends upon your Honor's ruling concerning felony murder. But if the court rules in the defense's favor on that, then that would be a paragraph that would be excluded.
Yes. State agrees.
Yes, Judge, it would have to be modified, correct?
Then I have 3.12, A, subsection A, single defendant, multiple counts, 3.12, subsection A.
No objection.
No objection from the state.
All right, parties agree with, then I have the actual verdict form, and the problem with the verdict form is, again, second-degree murder has to come out, right?
Yes.
And then the
Yes,
issue of felony is conceded in there.
No, because it would be an alternative.
All right. Can I ask you a question regarding the interrogatories? Any objection to those?
No, Your Honor, but before we get to the interrogatories, as to the first part, so B comes out because we're going to take out second-degree murder.
Correct.
And we also believe that subsection D should be subsection A. That is more consistent with the presumption of innocence. That the jury be offered the option to find him not guilty first and not last.
State have any position on it? They wish to be heard.
Yes, Judge, we might get to remain as standard in all the standard jury instruction verdict forms.
Thank you. Objection, no, it's overruled. Just leave the standard. Then I have 3.13, submitting the case to the jury. Is there any objection?
I think we're going to talk about these individual interrogatories first.
Oh, I thought you said you were okay.
No. Let me just.
Misunderstood.
Sorry. Let me confirm.
We're doing the interrogatories on the verdict form.
No objection.
No objection? All right, so that's 1, 2, 3, 4 interrogatories, there's no objection. So 3.13, that's submitting the case to the jury, that's again the standard, is that right?
Yes, Judge.
Is there any objection to that?
Which one is this, Your Honor? I'm sorry.
3.13, 3.13, submitting the case to the jury.
The only thing the state may suggest is that would say that the exhibits will be sent into the jury room with you, with the exception of any that are biohazard or anything of that nature. Those will be available for review in open court.
And also the celebrate.
Yes.
I think it's 64.
Yes. Well, and the state will provide a laptop for defense to review. It does not have access to the internet so that the jurors can review the items as they choose at their leisure, but I can tell you that the laptop the state will provide will not open the celebrate report. It's not.
Is that all right with the defense? Otherwise, you know, if they want to see something, we just bring them back in here into the jury room, and counsel would have to make it available and get it up and running. Otherwise, we can send the computer back. It's up to you guys.
Could I have one second? Can we have a moment on this?
Yes. All right, so we'll just provide the computer, let them take a look at it before it goes back to the jury, make sure everybody agrees with that.
Yes, last year on Thursday.
All right, so I owe you a ruling on felony murder. Is that it? Is that the only issue that I need to resolve?
I do believe in all related. Yes.
So I'll take care of that. I'll send out a letter, email to you today or tomorrow as soon as I resolve the issue in my own mind and finish reading the case. I mean, it's 38 pages. I haven't read it, so I'll read it and see if I can find any other cases on point. Oh, I trust you when you say these are the cases that are on point. That's it. So I'll look at that and see if I can come up with anything. And I intend to send an email out to all of you at the same time, just to tell you what my ruling is. Is that all right with everybody?
That's fine. Will the state send us a finalized copy of the jury instruction?
We're going to get to that in 2 seconds. That's what I want to have happen. Whatever my ruling is, to send them a set of instructions. And I want to know if the instructions don't meet with, if you're suggesting there's some issue that we need to resolve. I want everybody back here to resolve that issue tomorrow. All right? No ifs, ands, or buts. I don't want to be arguing about jury instructions before the jury comes in Thursday morning.
Understood.
So I'll get an answer to you today, and it's not going to take you much time to sort out whatever my ruling is, correct, Ms. Smith? So, and then you can get a set of instructions over to council, and how long would it take you to review those instructions?
Probably a half hour, an hour. And we will have Ms. Liberty respond to the court if we have no objections or if we have any objections. And assuming we have no objections, then we won't meet tomorrow.
Correct.
If we do have an objection, I understand that Ms. Bradley has a commitment in the morning, so I assume we'll meet sometime around 1:30, 2 o'clock.
Correct.
Fair enough.
Is that all right with everybody?
Yes, sir.
So just plan on being here tomorrow at 1:30, unless council, Mr. Nielsen, did I say it right?
It doesn't matter, Judge. You can call me,
No, I apologize.
Alice.
Adelstein. Mr. Adelstein,
Yes, sir.
if I hear from you and you send out an email to the state as well as to the court, let us know, let's say by 1 o'clock, is that all right? Whether you're going to be here or not?
1 o'clock today?
No.
Tomorrow. Yeah, 1 o'clock tomorrow. If we have to be here, it's fine with us.
No, you say let's notify the
Oh,
court.
notify the court by tomorrow.
By tomorrow at 1 o'clock.
By 1 o'clock.
Otherwise, be here at 1:30.
Fair enough.
Is that good with everybody?
Yes,
Was there anything else?
I'm just approaching the amended verdict form.
All right, you're going to send assuming whatever the final version is, you're going to make copies, correct?
Correct.
And for the copies, though, I need one for each of the jurors. That's 14. I'm going to need one for the court reporter, is 15. How many does defense need?
3.
18. And we need an extra one, right? 19. So let's say you make 20 just to keep a round number of it, so there's no issue if something gets wrong. Now, regarding the closing argument, I don't see how this is going to work in one day with a 4-hour closing, respectfully. I don't see how it's going to work. The jury, Gary, when I talked to Tom, he explained to me that the jury was instructed to be here on Thursday morning at what time?
9 o'clock.
9 o'clock. Where at?
First parking garage.
The parking garage. And then you got to bring them over here?
Yes. We'll escort them here.
You'll escort them
They'll have a
here?
designated area. There'll be deputies there waiting for them, and then we'll escort them.
And how long does that take?
Assuming they get here at a reasonable time, and they're
Assuming
not.
they get here on time. I know we've never started on time because we
They'll
always
they'll have to put everything through the scanner, their luggage and everything. So I would say 30 minutes.
So assuming we start at 9:30, and I think that's a big assumption. My guess is we start at 10, all right? Because we've told the jury to be here, and there's always somebody who's not showing up at 9 o'clock, always late, and by the time we resolve whatever issues we have, we start at 9:30. And that's, that's just the nature of the beast, so to speak. But assuming we start at 10 o'clock, and you go 3 hours as the closing, without taking any breaks, you know, you're going to be into 12:30, 1:45, and your opening argument. We take an hour or so for lunch, come back, you know, at, let's say 2 o'clock, and defense puts on their argument. There's no way we can finish all this. There's just no way. And we indicated, you all told me you wanted to do it in one day. It just, there's not enough time to do it because the first night they have to be out of here by 5. They come, they make arrangements to get them out of here by 5 o'clock. They've asked me to assure them because they have to make arrangements over at the hotel where they're being sequestered at and things like that. Friday they'll pick them up. You know, they're working on all those arrangements, and they'll be over here to start their deliberations Friday morning, and they'll get them over here fairly early because they'll have them. They've all had breakfast arranged already. They're working on all of that. So my thought is, you can't have 4 hours. It's just not going to work. You can't have 4 hours. If you go 3 hours, put an opening 2 hours, rebuttal an hour, that gives Mr. Alstein 3 hours, and I don't know who's doing the closing. Are you doing who's doing the closing?
I am.
So that gives him the time in the middle, 2 to 3 hours. Because whatever I give you, I got to give him.
I understand.
And then you have an hour for rebuttal. I don't know if you need really need an hour for rebuttal, but the problem is it's cutting really, really close to that 5 o'clock time. That's the problem I have.
So you're saying even asking for 3 hours would be too much? Is that what you're?
No, I'm saying I think we can get it done in 3. And again, I have to hold out the same time for the defense as for you. But you know, counsel's indicated to me he doesn't think he's going to need 3 hours. But you know, if things change, he's entitled to the same time that I give you. But if I give you 3, and we started, you know, be optimistic, we start at 9:30, all right? 9:30, 10:30, 11:30 is your opening argument. Okay, we got to take a break in there someplace. It's going to take me a half hour to read the instructions. So you'll probably be done with your opening argument if you take 2 hours somewhere around noontime, 12:15, 12:30, something like that.
So is it your Honor's intention to read the instructions to the jury first and then closings?
That's what I typically do.
That's fine. The state has no preference on that.
Because you're going to use the instructions I thought in closing.
Yes.
And so I would.
I'm sorry. I have no problem with them using the instructions before you read the instructions, since we have them. So may I suggest considering starting closing arguments immediately, because at least if we run out of time, the court can instruct the jury Friday morning. This way, we're assured that closing arguments will in fact be complete on both sides. And if we agree to the jury instruction, then I see no harm in either side using those instructions.
My understanding from the rules are you can do it either way. So up to however you want to do it. So, you know, I leave it to the attorneys, basically. You tell me whether you want to read it first or last. I typically read it first, not my preference. That's just what the attorneys want me to do typically. So I don't really care one way or the other. You tell me how you want to handle it. That's number one. But if we do 3 hours, just talking about the time frame, if you do 2 hours,
Yes.
and you get your closing done in the morning, let's say, we take an hour and 15 minutes or so, that's what we've been doing for lunch, come back, Mr. Alstein can have his 3 hours thing, and then you come in for your 4th hour at the end, and it should be, you know, if he takes the time, he's telling me he's probably not going to use the time, but he's entitled to it. That brings us up right around 5 o'clock.
Yeah, I will, if you're instructing us to do 3 hours, I will do my best to get everything done in the 3 hours. I'm doing it 2 and 1. So if it might go over a little bit, it might be under a little bit. So I don't write it out word for word.
I would ask you to do the instructions last, since we agreed to it, and in the event that we're running late,
Stop
then
you for a second, Gary. What happens if we're running over a half hour on these things? Because Tom says you got to get them out of here at 5 o'clock.
I don't
I've
think.
never had the issue come up.
Yeah, I don't think it's such a big deal. I can check with him to see what's the latest. I know the first night is kind of lengthy because the things we have to do before we take them there.
All right, so we'll see how it goes. I'll get your a ruling hopefully today on the felony murder issue, and then we're going to meet back here 1:30 tomorrow, unless I hear and you hear from defense counsel that they're agreeing to the instructions to preserving your objection. But I mean the form and substance of the changes that we made, they're in essence agreed to conform with my ruling, and
Yes, sir.
otherwise everybody meets back here at 1:30. Okay?
And so the only thing I could think of to deal with or address prior to the closing is if defense is going to object every single time I call the phone number of the defendant. If we have as opposed to having to argue that every single time, if the state make sure there's, now argument and the state has proven that phone number belongs to the defendant.
I think she has the right to refer to it as the defendant. I also have the right to argue that if I so choose, that they haven't proven it. But I think at this point, that's fair comment on the testimony.
And that's what argument is. It's comment on testimony. You're the way you're receiving it. So I doubt there would be an objection. But counsel's just telling you that that's it's a threshold question in the trial as to whose cell phone it is, and that's why you asked to let all those emails and text messages and all that kind of stuff in there.
But that was one of the reasons I was asking for 4 hours, because I anticipated a lot of objections on that specific area.
We're not going to object on that. She's entitled to make that argument. Your Honor, there's just one thing remaining, and we're not sure that we know we made a motion for judgment of acquittal at the conclusion of the state's case in chief, at the conclusion of the defense case. We are renewing it at the conclusion. I guess the state didn't put on a case, but just in case there was any procedural requirement that we do so in order to preserve our rights, we are renewing at the close of the state's non-rebuttal case our motion for judgment of acquittal.
I thought you did, and I thought you did that earlier today, but if I'm mistaken, I'm sorry. But you said, I thought the last time there's no other argument, you're standing on the arguments you previously made. Is that correct?
Yes, sir, correct.
And the state have any additional argument?
Just from the Lynch case, Your Honor, I would also cite as to the premeditation aspect, there's case law on that as to how premeditation can be proven.
I'll defer ruling on it, and I want to read the case over, and I intend to get you an answer today. If not, it'll be first thing in the morning.
Yes, sir.
All right?
Thank you, Your Honor.
Good. I spoke with Tom. 5:15 today.
All right?
So I would again, based on that, ask the court to instruct the jury last.
Well, I think the state has no objection to it.
Oh, okay, fair enough. I missed that.
I'm going back and forth on that one. I'll think about that and we can tomorrow. I prefer the court to have to read the instructions first on that, so that that's the baseline and that's already been given from the court. So.
Typically, that's the way I do it, but it's discretionary. It can go either way. See what the issues are. And my only concern is making sure we get it done. But I don't want to, instructions are important. They're going to have a hard copy of the instruction, but I don't read these instructions really fast. I take my time reading it. I'm not going to just fly through it. I just don't do that.
And we're asking that it be read last. So we're clear on that.
I understand. I want to hear what the state has to say. She says she's going back and forth, and I do understand that discretionary. It's up to the court. Okay? All right. Anything else to discuss?
No, sir. Thank you very much.
How about you, ma'am? Anything else to discuss?
No, Your Honor.
See everybody back 1:30 tomorrow, unless I hear from you.
You're going to hear from the designated person that Judge Siegel's appointed, and that is Miss Liberty, with all due respect.
With all due respect, I'm sure that Judge Siegel didn't appoint any one of these.
Oh, yes, he did.
Warriors.
He did. He did. He absolutely did.
I disagree with Mr. Allison. That is not my recollection of how that day was